record. Right, so that's press the record button. Right, that's 4 o'clock. I'm just going to start then, guys. Okay. Good luck, everyone. Right, let's see if we've got any people joining. We still have. Hope this is okay. We've only got 4 participants so far, so hopefully people will start. There we go. That's people are just starting to join the webinar now. So that's great. Thanks very much for that. Well, welcome everybody to the. This is our first webinar of 2021. The last webinar we did in December, and that seems an eon away, doesn't it? Really, in terms of everything which has happened since then. So, my name is Chris Elias. I'm a relationship director with Thring. So it's good to have you back for our first event in this year. The webinar is being recorded, so if there are any points that you missed during the session, don't worry, you will be able to access it again. And also, if you want to share it with anybody as well, any colleagues or any other clients, please feel free to do so. So that'll be available to you as well. The Business Health Matters webinar series is a program that Thrings have devised throughout the pandemic. So hopefully we can bring our clients up to speed, up to date with various issues which are happening for them throughout the pandemic. It's been very well received so far, and we've got a full series of events for 2021 running each month. Our next webinar will be in March, and that will be on a property related subject. So keep an eye out for that. Today's webinar, however, is going to focus on some practical legal tips as hopefully we come out of the pandemic, and what businesses can do to thrive as the world becomes a better place. We've got 3 speakers for you this afternoon. All the W's. First off, we have Caroline Watson. Big wave from you, please, Caroline. Thanks very much. Caroline is a partner in the commercial disputes resolution team, and she's taken part in a number of webinars previously, as we've been tracking one particular case as it's worked its way through the court. So we've got a very important update on that. So we look forward to what Caroline has to say on that. Second up, then we have Mike Westbrook. Thumbs up from you, Mike. Yep, there we go. Great. So Mike's a partner in our private client team, and one of the things which we'll be looking at today is, well, who knows what Rishi is going to come up with, and Boris, in terms of what tax changes might be potentially on the horizon as we come out of the pandemic. So Mike will be running through a couple of those issues there, which we should all give some consideration to. And then finally, we have Kerry Willis-Fleming, who is a solicitor in our employment team. And, as we're probably all sitting in our lounges at the present time, and, the employment structure in the UK has probably changed to the greatest level, and it probably has done in centuries over the last 12 months. So Kerry will be looking at some sort of key factors which are impacting on us in our day-to-day lives in terms of both employment and employees. So that'll be really good as well. This will be an interactive webinar. There'll be a poll at the end of each section, where we will just try and garner some information from you, which helps us enormously, really, because we can get some feedback in terms of what clients are thinking. So we can use that to structure future events, and also, publish more relevant articles as well as we go along, be it through our website, blogs, or through LinkedIn, whatever. So that's very important to us. You'll also see that there's a Q&A button at either the bottom or the top of your screen, depending on what sort of device you're using. So if there are any issues which come out of the presentations as we go along, please feel free to jot them down, and we'll try and address them as we go along. If they're perhaps a bit more personal or more detailed, we'll pick them up after the webinar. So don't worry about that. The formal session will probably run for about 30 minutes or so, and we'll have time for 15 minutes of Q&A. So hopefully we'll get everybody ready for tea by 4:45, quarter to 5. So we won't be hanging on any longer than that. So that's the formal bit out of the way, let's quickly move on to our presentations then. So first up, we have Caroline, and I as I was saying, Caroline, you're almost like the bad penny, aren't you? Really, of Fringe.
Yeah, seems to keep on coming back on this one, don't I?
you keep coming back and back and back. So, but obviously, this court case, there's been some good news recently for policyholders. Do you want to expand on that? What developments have happened since we last spoke?
Yeah, absolutely. And I think actually it's really good news that I've been able to speak to you 3 times in the last kind of 7 or 8 months on this particular case, because it shows the progress that's been made with kind of a real issue that's been affecting upwards of 400,000 businesses in the UK as a direct result of COVID. So that's why I'm here again this time. And the good news is we finally have some clarity for policyholders and a final decision in the legal dispute. So that's the great news. To summarise where we were when I spoke to you in December on this last, is that we'd had the initial case started by the Financial Conduct Authority, who were bringing a case on behalf of policyholders to address some inconsistencies with how the insurance industry was approaching certain types of claims for business interruption losses resulting from COVID. These specifically were losses not based on property damage, but for losses related to other events. Most business interruption policies don't cover anything other than property related damage. So if there's been a fire, for example, but where specific policy extensions have been purchased, there were real inconsistencies with how the insurance industry were dealing with those types of claims. Back in August, the first court hearing of the FCA's case took place. That decision was handed down by the High Court in September, was broadly seen to be favouring policyholders. As most commentators anticipated, it was appealed by the insurers, who were seen to have lost the case, but also it was appealed by the FCA for greater clarification on certain issues as well. That appeal was heard in November, and we finally had the final judgment from the Supreme Court on the 15th of January. And that was a widely reported decision, which I expect everyone's kind of aware is rumbling on in the background.
Okay, so we've had the Supreme Court decision. What did the Supreme Court decide? So
this is a 120 odd page judgment. So in order not to bore everyone to tears, I've tried to kind of summarize the really, really key points from it. The Supreme Court looked at 3 types of policy wordings which seem to have the most impact for policyholders here. They were disease wordings. This is where a policy provides for the occurrence, for the cover for losses of the occurrence of a notifiable disease within a certain vicinity of the premises. The Supreme Court backs the High Court's decision that these types of clauses should provide a business with cover for COVID losses, because COVID is a notifiable disease. Cover wouldn't only be confined to losses caused by the direct cases of COVID within that vicinity of the premises, but would also be extended to see COVID as a bigger thing, which it has been for the country. So the great news on that is that payouts, that may lead to slightly higher payouts for policyholders. The second type of wordings that the court looked at were called prevention of access clauses. These are where you have been prevented from accessing your business premises because of a government restriction. Now here, again, good news for businesses, the Supreme Court interpreted the policies more widely than the High Court had. To summarise, if you have been prevented from accessing your premises by any of the restrictions that have been imposed by the government, you are likely to be covered under your policy. The other important change here from the High Court decision was that the Supreme Court found that where there had been a partial closure of premises, the losses resulting from that partial closure could be covered as well. So I guess this is really important for kind of a key example would be a cafe or a restaurant where they haven't been able to open for eating, but they've been able to kind of mitigate their loss by running a takeaway business. They'd be able to recover their losses for the closure of the eating bit of the premises, and that's a really important extension from the High Court's decision. The third type of clause that the Supreme Court looked at were a combination of those two clauses. So a premises being restricted because of the occurrence of a notifiable disease within the vicinity. And again, Supreme Court supportive that policyholders with these types of wordings should be covered for their COVID losses. Those were the kind of actual policy types that the court looked at, but one other very important implication for policyholders from this decision was that insurers had argued that in the assessment of the value of claims based on kind of the economic or the financial forecast for that business over a certain period of time, and this is called the trend clause, that COVID should be taken into account as impacting on that industry in any event. Importantly, the Supreme Court held that COVID couldn't be taken into account in looking at the trends of a business. So in short, insurers couldn't say, well, yes, you're covered, but you wouldn't have had the financial losses that you're claiming because COVID would have affected you anyway. So
you'd have treated it as there'd be no COVID effectively.
Absolutely.
Okay, brilliant. Okay, cool. Well, I think what we'll probably do now, we're just going to break. I'm going to run a quick poll while Caroline moves on to her final topic. So just launching the poll. So if everybody can see that and answer as we go along, that will be great. So I guess then, decision has been made. What does this all mean for policyholders?
Yeah, I think if you had one of these types of policies, it is great news for you. I think to temper the very, very positive media portrayal of this case, it affects around 400,000 businesses. So it is not every business by any stretch of the imagination that had business interruption insurance. But if you had business interruption insurance, which wasn't solely based on property damage, this case will affect your prospects of successfully claiming on that policy. I guess the FCA summed it up really well and commented that the judgment decisively removes many of the roadblocks to claims by policyholders, and I don't think I can put it better. Than that. It's also been really good to see that the FCA have taken really swift action in the instructions that it's given to insurers and how they should be dealing with claims now. The FCA has wrote very swiftly after the judgment to instruct insurers to deal with claims quickly, to provide interim payments where they were necessary, and to quickly and clearly communicate with affected policy holders. So if you have been affected by this decision, your insurer or your insurance intermediary should have communicated that to you by the 29th of January. If they haven't, you should be getting in touch with your insurer swiftly. It's important to note that where claims have previously been refused, this judgment may have an impact on that. So there were certain types of clauses where cover has been extended by the Supreme Court decision, and it may be that your claim should be reassessed now. And again, swiftly contact your insurer or your insurance intermediary to look at those and ask questions if you think you should have been covered, but cover was initially refused many months ago. There's really loads of helpful guidance on the FCA website, and anyone with who thinks that they've got an issue under one of these policies, that should really be one of your first ports of call. There's a really helpful policy checker where the FCA will take you step by step through a series of kind of online questions, leading you to an answer as to whether you should be whether you're likely to be covered here or not. The other really helpful thing that's on the FCA website is information on how you might be able to prove that COVID occurred within the vicinity of your premises, which is necessary for some types of policies. There's draft guidance there at the moment. It's very detailed. It's going through a consultation, but it's available and there for use for people who are affected. I think to summarise all of that, and I appreciate it's a lot of information, key points are keep up a dialogue with your insurer or your intermediary if you think you're affected by this decision. Take really early advice if you don't think your insurer is dealing appropriately with your claim. And don't forget that you may have separate claims from each of the lockdowns. So we're now on number 3. And this decision was related to the first lockdown. That the principles will apply to the November and the January lockdowns as well. So don't forget, even if your first claim is still pending, to issue those subsequent claims as well.
Okay, thanks, Caroline. So some very pertinent things there. It's quite interesting if I share the results for our poll now, if everybody can see that. The vast majority of people are not don't think they're going to be affected by the Supreme Court decision. So I don't know whether that's a good thing or a bad.
Well, I think that probably fairly 5%. I think that fairly bears out that actually I would imagine the 400,000 figure of businesses affected is equivalent. Pretty indicative of that. Yeah. So,
okay, so that mirrors itself across probably then with our audience this afternoon then.
Yeah, which is why I said that great good news story. I suspect as with many of these things, it's been a little bit hyped in the media because of the amounts of businesses that it does impact, but important for those that it does.
Okay, that's lovely stuff. Thanks very much for that, Caroline. Mike, on to you next, and I guess really what we do have to say, what you're going to say is probably fairly heavily caveated, really, in terms of what might happen in due course, because we don't really know. So I guess, but there are, ultimately there are tax and structuring opportunities out there for businesses to do structure their businesses in an efficient way. Do you want to tell us some more about what options might be out there, Mike?
Yeah, sure. I mean, as you say, it is to be heavily caveated in the context of potential changes to the tax system that might be out there. Also, just in the interest of time, I primarily look at capital taxes for business owners. So really, inheritance tax, capital gains tax, and sort of taxes sort of more incidental to that. So I'll focus on that for these purposes. But I mean, so as things are at the moment, particularly if business owners are looking to exit their business or to pass it on to the succession planning for their businesses, then it's the reliefs for these capital taxes that are really important. And particularly for inheritance tax purposes, for example, the availability of business property relief for trading businesses, shares in trading companies, interests in limited liability partnerships, and so on. Particularly approaching a business sale, for example, it is possible to take advantage of that relief by, for example, transferring part of your interest in that business into a trust while it still qualifies for that relief, and then ultimately the proceeds will be outside of your estate for inheritance tax purposes, and that's a tried and tested method and still available as things stand. Capital gains tax, there's what was entrepreneurs relief, now known as business asset disposal relief, still available, less valuable than it was a year ago. The lifetime allowance on gains that you could realise and secure a 10% capital gains tax rate on those gains, reduced from 10 million of gains during your lifetime down to 1 million of gains in the last budget. There's still a query over whether that might be taken away altogether, possibly replaced by some form of relief that's designed more to encourage investment on the way into businesses rather than to reward it on the way out. And another one that we're seeing an increasing uptick in interest actually is called an employee ownership trust, which is it's a form of employee benefit trust. It was brought in by the coalition government, so it's been like some time. Key features of it is that what you have to do is actually transfer controlling holding into a trust that is there for the benefit of the employees. And what that does actually, when you dispose of your shares in that way or interest in the business, you don't pay any capital gains tax on that. So those, again, still around, and we're seeing increasing interest in those. So there's still, there are opportunities out there that have been around and continue to be around, subject to what future changes there might be around the corner.
Mm-hmm. Okay. So what short, medium, long term, what do you think those potential changes might look like there, Mike?
We've had a lot of, in the last few years, particularly with regards to those taxes and particularly with regards to inheritance tax, there have been a number of two reports by the Office of Tax Simplification, the OTS. We've had an all-party parliamentary group on inheritance and intergenerational fairness, producing a report on inheritance tax with some recommendations. We've also had a wealth tax commission report as well. All that's got to now be said in the context of an unprecedented bill to pay, essentially, with the measures taken through the pandemic, and changes must be afoot. Really, we've got the sort of short-term knowns, to coin a phrase. We know that, for example, the stamp duty land tax holiday is going to come to an end unless it's extended on the 31st of March. We've got the introduction of a non-resident SDLT, stamp duty land tax surcharge, an additional 2% for non-residents. So, for property businesses, property rental business, property development businesses, that can have an impact one way or the other if you're acquiring or indeed selling properties. So that's something to be borne in mind. We've got the short-term unknowns. It's widely been talked about and expected that there will be some change to the capital gains tax rates. We're expecting an announcement in the March budget. Thought that they could be brought in line with income tax rates, possibly, so we might have a top rate of capital gains tax of 45%. But there's a balance to be struck there, because the higher the rates go, the more likely people are not to carry out a transaction. So it may be that the rates go up, but not quite so much. When may it happen? Well, if past form is anything to go by, they could make the changes on the day of the budget, on the 3rd of March, or they could come into effect on the 6th of April instead. We might also see a possible increase in corporation tax rates and income tax rates, possibly. Again, we don't know really. But looking through to the medium term, there have been these reviews of inheritance tax reliefs in general the one that's going to affect business owners, or potentially could affect business owners, it looks like a small tweak to the rules. Essentially, if you have a mixed trading business, so you could have a trading side of the business and an investment side of the business. So you might have a portfolio of let properties, for example. So long as that business is more than 50% on the trading side, on various factors, then it is trading for the purposes of business property relief. For capital gains tax, that ratio is actually 80%, 20%, and what they're considering is bringing the inheritance tax rules on mixed trading businesses in line with capital gains tax rules. So you'd be looking at 80-20% test for inheritance tax. Again, it could be something, it'd be a relatively easy change to make. It could have a real impact on rural businesses, actually. There's rural businesses particularly have that balance to strike, and diversified rural businesses. So it's something to watch. Could be a small change with far-reaching ramifications. As I said, they could remove the business asset disposal relief altogether for capital gains tax purposes. They might reduce annual exemptions and so on, but it remains to be seen exactly what they'll do there. Longer term, these reports that I've mentioned, the reviews, particularly on inheritance tax, have recommended a fundamental structural change to the inheritance tax system. Inheritance tax is widely thought of as being massively complicated and unduly so for what it tries to achieve, and a possible simplification of that, possibly with a reduced rate down to 10% has been discussed, and what that could do is mean that people are happy in inverted commas to pay a lower tax rate, and overall what that means is that the overall tax take might increase. But again, that would be a longer term change, and it's only been consulted on at the moment. There's also been the suggestion of a wealth tax being introduced, but that's a political minefield, I think, to say the least. So yeah, longer term, it would take a lot of parliamentary time, a lot of political capital and will, which I think currently is being devoted elsewhere.
Okay, so what action should people be taking then, Mike? Any recommendations?
Yeah, well, I think there's always the old adage is don't let the tax tail wag the dog, and I think that's right.
Say that.
Well, all decisions tax should also always be a very, very important consideration, but not the only one. So fundamentally, are you thinking of doing something that is right for the business, that's right for you? What are the tax implications of doing so? There are some things we know are coming. There are some things we're pretty certain are coming. So there's an argument to say, well, whilst we know what the tax system is, take steps now. If you were going to do something in 6 months' time, you could do it in a month or two. Well, why not do it in a month or two? But longer term decisions, when the longer term outlook is so uncertain, it's hard to say do something now, because we might have some tax change happening in 3 to 4 years' time. I think it's keep things under review, do things that you can do that make sense now, whilst we know what the tax system is, but be vigilant as to changes coming down the track.
Okay, thanks very much for that, Mike. I've got one poll for you, Mike, but I think I'm just conscious of time, and I want to make sure that we've got enough time for Kerry. So might just keep that up my sleeve for later, because that might start some debate as well. And I would just like to say we've got some questions coming in. So if anybody does have any burning issues, please don't hesitate to fill in the little Q&A section, and we'll try and address those if we can. We've certainly got something for Carolyn to pick up on later. So Kerry, welcome. First time in the hot seat. So glad to have you here. And as I said in my preamble, really, we've seen a huge amount of change, haven't we? Really, in the last 12 months in terms of working from home. So that's had incredible benefits from employees' perspective and employers' perspective to a degree, in terms of cost, time saving, travel saving, efficiencies. But we know there are also concerns as well, aren't there, really, in terms of people's well-being, mental health, people working from home, not seeing anybody from day to day, living on Zoom. So I guess really, what practical tips can you give to employers to sort of maximise opportunities that have come from this change in practices?
Thank you, Chris. So I think ultimately I could probably distill those tips down into 5 top tips in terms of making the most of employment opportunities in the wake of remote and flexible working. The first of which is that employers just need to remember the duties of care to their staff and their health and safety obligations. Out of sight shouldn't mean out of mind. You still do need to bear in mind that whilst they may not be sat in your workplace, you do need to make sure that they are their well-being and their safety is good. For those of you that haven't already done it, I would recommend going onto the HSE website. They've got some useful tools in their toolbox, including desk assessments. So even though you might not be able to access employees' homes to be able to see where they're working, albeit you can see a lot of it on Zoom, you could ask them to complete a form. That doesn't delegate your responsibility as an employer, but it could give you a good starting place to then review it and see what needs they have. Likewise with well-being, as Chris mentioned, a lot of employees are suffering from mental health problems and anxieties caused by the lockdown. So it's worth keeping in touch with your employees, ensuring their well-being and signposting them to relevant organisations such as Mind and places where there's good tips on how to keep yourself active and mindful during these times. For those employees that are particularly struggling, you could refer them to occupational health. And for those employees with disabilities, remember that you've got duties of care to them in terms of making reasonable adjustments as well. So second top tip is in relation to managing performance. Now, clearly that is a lot harder in a remote working world. You've not got your employees sat next to you that you can just oversee. So there may be many employers who are thinking, oh, well, in that case, maybe I'll install some software onto people's computers so that I can monitor exactly what they are up to. If you're thinking of doing that, I would recommend having a look on our website. We've got a great article on there about monitoring employee communications. In a nutshell, just be mindful of your GDPR and data protection obligations and privacy obligations, and make sure that employees know that they're being monitored and the purposes for which they are being monitored. I think the better way to be able to monitor employee performance is just to set reasonable expectations and deadlines and communicate these with staff so that they can proactively work with you to achieve what it is that you need them to achieve, rather than react to when they don't necessarily achieve what you want them to do. Third top tip, review your contracts, policies and procedures. Are they still fit for purpose in this current working environment and the way that you're planning on operating going forward? There's been a lot of legislative change actually in relation to contracts of employment that we saw in April of 2020. There are different things that you need to make sure you include in contracts. So that might have passed some people by, given that they had other priorities at that time. So review your contracts, make sure that they're up to date and fit for purpose. In terms of policies and procedures, what I would say is there's a number of them that you would need to have a look at and just check across the board that they are doing your job for you. But ultimately, have you got a home working policy? Do you need a home working policy? Number 2, IT and communications policies. Are they fit for current purposes? There's a lot of people working from home. Have they got confidential information that belongs to you that you need to be protecting more proactively? If so, have a little look on the ICO website. The Information Commissioner has set out some really good tips on protecting data remotely. Such as, making sure simple things like making sure you password protect your IT equipment and that people in the household haven't got access to the computer. I've heard stories about teenagers getting onto, people's work computers and uploading a TikTok video to the firm's Twitter feed. Not necessarily what you're really going for, for your business. So just make sure that your employees are complying with those policies. And the third policy that you really do need to dust off at the moment is the flexible working request procedures. A lot of employers may have just bunged those to the back of the cupboard and thought, hopefully no one will ever get involved with that. It's really cumbersome, it takes time, and it's all very prescriptive. Now employees have had all of this freedom. They may well want to continue with the freedom going forwards. So any employees with 6 months service can actually have the request made and have to have it dealt with appropriately. And it's of course going to be harder to justify refusals to work flexibly when employees have already been working flexibly. So that's something to bear in mind. Mm-hmm. The fourth tip that I've got is where employers have made efficiencies. If you've already lost headcount, you're working on a lean and agile workforce basis, you may think as things get busier that you want to flex up your workforce by getting more consultants and contractors in. Bear in mind that the laws in relation to taxation of consultants and contractors have changed, and they're going to change in April of this year. It's called the IR35 rules. And basically, it will now be the obligation of you as the person providing that work to review their status for the purposes of tax and determine whether you should be deducting tax and national insurance at source, rather than the person providing those services through their personal service company. So if you have got contractors doing that, my advice would be to look into that now. If you're not sure about status, the HMRC website has got a CEST tool, CEST, that can help you to determine status. That would be determinative. As long as you've dealt with it appropriately in accordance with the form, it would be determinative for the purposes of tax. However, it's not necessarily the same for employment law purposes. So it is a bit of a tricky area. Any questions, fire them our way. The fifth and final tip I've got would be how to thrive in the modern working environment. Use of remote collaboration tools, I would say. At the moment, it's very difficult to manage those junior members of staff and or share ideas that normally you would just walk over to someone's desk and say, oh, I've got this bright idea. So make sure that your employees have got the relevant IT equipment and collaboration tools to enable them to have those more informal interactions, such as Microsoft Teams, Slack and Trello. They're coming into the fore at the moment, and it helps to keep your staff engaged and keep your business culture alive, really. So those would be my 5 top tips.
Your 5 top tips.
Yeah.
Thanks very much, Gary. So before we just sort of move into the final part of your section, we've got a poll which we're going to just launch now. So if people would like to respond to that as we move into our final section. So I guess throughout the afternoon we've been talking about the dreaded C word a lot, but we've missed out on the B word, haven't we? The B word seems to have disappeared a lot recently. So what about Brexit? What's going to be the impact of the Brexit changes now that everything's been signed off in terms of employment law?
So it's an interesting question, Chris, because as you say, I think it's been eclipsed quite a lot by COVID in terms of employment law. But and I think the answer is quite relatively at this stage, quite simple, which is there is very little change in terms of general employment law. So basically, the law as it was before we exited Europe pretty much stands as it is. Our courts and tribunals do now have the opportunity to depart from previous precedents that were handed down by the ECJ. So over time, there may be a change, but I don't think it will be an overnight change in terms of how our legislation is interpreted. And the government have said that there is little political appetite for a bonfire of employee rights. And I think that really does show from the way that actually not all of our employment law comes from Europe. Some of it was domestic, including things like shared parental leave, flexible working requests, as I said, the cumbersome forms and procedures, that was actually domestic. And sometimes things that came in through Europe have also been gold-plated. So, through Europe, you're entitled to 4 weeks worth of holiday. In the UK, it's 5.6 because of our bank holidays. So I don't think there's any potential for those things to be screwed up and put in the bin anytime soon. What I would say is that there is the potential for the government to decide, actually, we are going to remove some of the red tape for businesses and make complex areas of employment law perhaps a little bit more simple. And so the sorts of things that I've heard on the grapevine might be set in their sights would be potentially making it easier to harmonise terms after a TUPE transfer, how to calculate holiday pay for anyone who's involved in payroll and has the nightmare of having to try and sort that out. They will know that that's never an easy task. Perhaps lifting the cap on the 48-hour working week, and a few things like that. So there is the potential, but it all comes back to the withdrawal agreement, which basically says that we can't be putting ourselves as a competitive advantage in trade and investment. So if we do make these changes, then there is the potential financial repercussions that might come in to prevent that from happening from Europe. The area that really has changed is immigration. So now anyone who has enjoyed the rights to come and work in the UK from Europe because of free movement of workers, they should be encouraged to put in sort of applications for pre-settled status or settled status if they've been in the UK now for 5 years. Those applications need to be in by the 30th of June. And so what I would say is, if you have got people who are working for you who are from Europe, then you will need to carry out right to work checks from the 1st of July to make sure that they have put in those applications and have the right to work. Otherwise, you could be in trouble for employing people when you shouldn't be. And if you are going to need to draw upon talent from Europe and elsewhere, then of course you need to start thinking about sponsorship licenses and ensuring that you can properly gain the employees that you need through skilled workers or intragroup transfers. Any of those sorts of things, of course, our immigration team would be happy to discuss with you further. But those are a quick canter through what Brexit might mean for employers.
Okay, that's lovely. Thanks very much for that, Kerry. So I'll just I've just closed the poll, so we've just got some results to chat through. So if I just share those with everybody on the call now. So I guess really from a health and safety perspective, it's probably almost a 50-50 split there in terms of those who haven't carried out health and safety assessments or are currently under consideration. So important for everybody. Kerry?
Yeah, I think so. I think a lot of employees ended up having to be sent home at very short notice, and employers had quite a task of making sure that they were operational and had all of the equipment that they needed to get by. I think now that it's becoming more of a permanent thing, it's definitely worth ensuring that you go on the HSE website and that you are complying with risk assessments, so that those employees who have been hunched over the kitchen worktop for the last few months don't suddenly come back with injuries for doing it. So I think it's worth doing that.
Right, it's very interesting as well. I see that over 76% of those who responded have said that they've reviewed their policies and procedures so that they're fit for purpose for flexible working. So that's really encouraging.
Yeah.
And in terms of monitoring staff performance via software, nearly 20% of people are currently doing that. What's our experience, Kerry? Have we had many clients contacting us at all in terms of what can and can't be done?
So we do get those questions, and I think it's just really important to balance your right as an employer to know exactly what your employee is doing against their rights to privacy, and to ensure you're not encroaching upon data protection legislation, which has sort of been brought to the fore a bit more by the GDPR, and is still enshrined in UK law now. So I think definitely go onto our website, have a read of our article about employee monitoring, and make sure that you're complying with all of the things that we've suggested on there in the first instance.
Oh, that's brilliant. Thanks very much for that. And I suppose a question from personal experience, really, with my banking hat on, or my former banking hat on, certainly the banks I worked for, they had a real paranoia about a clear desk policy at night, so that everything had to be locked away in a fireproof cabinet, a secure cabinet. What, how were people fixed? Because I'm sure there are lots of employees with, corporate papers at home without that facility of security and storage. Any recommendations?
Exactly. So I think if you have got employees that are at home with confidential documents, then you do need to be really careful about how they are storing and destroying those documents, and make sure that your IT and communication policies are up to date with that. If you've got any concerns about that, I would say go to the Information Commissioner's office website, and they have got some really good tips on how to secure your data whilst your employees are remote working.
Okay, so the questions seem to be coming your way today. Okay, so what about questions come in? Can we ask EU members of staff if they've applied for or have been given settled status?
Yeah, so I think you can have that conversation. You can't force employees to do it. It's up to them whether or not they want to do it, but clearly if they don't do it, then come the 1st of July, you wouldn't be able to employ them any further. So I think it's worth having those open communications with employees to make sure that they're aware of their rights to be able to apply for pre-settled and settled status, and maybe even assist them with it if they are going to struggle with that process. It can be really unsettling for employees in that position. So I wouldn't be surprised if there are many people struggling, and so it would be worth putting some manpower behind helping them to do that before the 30th of June deadline. What I would say is just be careful. You don't want to be seen to be singling people out or discriminating on the grounds of race or nationality. So if you are going to ask those questions, just make sure you're doing it sensitively and in an appropriate way.
Mm-hmm. Okay, lovely, thanks. And one final question for Caroline then. If people hadn't bought policy extensions, does that mean end of sports really in terms of potential claims on BI cover?
No, I mean the other option, and thank you for the question that's been raised about this, is there may well be the potential for issuing claims in negligence against your broker. And certainly the kind of commentary is that there's going to be a whole raft of these types of broker negligence claims. What would be looked at to determine whether there was a viable claim there is what you'd ask the broker to advise on, whether they'd advised on specific risks. So if they had raised the risk of a pandemic and cover for a pandemic, and you had decided that you didn't want to insure against that, then unlikely to be a claim there. But if you hadn't been advised on it, or you had asked for coverage and you weren't given cover, that's a different story. So I think if your insurance has been inadequate and you've been advised through a broker, have a look back at what you at your communications with the broker at that stage, and take advice on whether there's a potential claim there, because it is a very real and live group of claims and prospects for people who have maybe lost out.
Okay, fine. That's brilliant. Now there was one further question which we appear to have lost, which came in from Keith Surrey, I think it was. So I've lost it on my screen, Keith. So if
sorry, Chris, I just answered it. That was the question.
Oh, you're too quick for me then.
Sorry, Chris.
Oh, was it? Oh, right. Good. Okay, so I missed out on that. So that's brilliant. So, folks, I'm just conscious of time. It's coming up to 10 to 5 now. I think we've covered an awful lot of ground there, which I hope you found interesting and informative. As ever, if there are any aspects that require any further information or clarification, please come back to any one of our panelists, and I'm sure we'd be able to help you. Even if they can't, one of the colleagues will. We're in a dynamic environment, and certainly in terms of Mike's section, in terms of what's happening on a tax front, that we could see that moving and changing quite considerably over the coming weeks. So please, if you do want advice, please reach out to Mike and his team. We'd be more than happy to help you and answer any queries that you might have from the information that we have. So all that remains is finally for me to say to thank all our panelists. I really appreciate your time and the work that's gone into your presentation today. That's been great. Thank all of you for attending. Hope you found it informative, and we look forward to seeing you again in March for our next property centered meeting. So have a good evening. It's Thirsty Thursday in my book, so I'm sure you'll have a glass of wine tonight to celebrate. All the best, folks. Take care. Bye.